Good night. As you know, each side will have 15 minutes for oral argument. The appellant may reserve up to 5 minutes, and if you wish to do so, please let me know, and I will give you a hand signal when you are at your time.
Thank you, Your Honor. Good morning, Your Honors, and may it please the Court, please allow us on behalf of the appellant Ronald Phillips, I would like to reserve 3 minutes for rebuttal.
Thank you.
This morning I would like to focus on assignment of error number 2, asserting that the trial court erred by dismissing Mr. Phillips' successor post-conviction petition when he raised sufficient operative facts to merit relief or at minimum an evidentiary hearing. And specifically, the claims I would like to focus on are claims 9 through 13. Since 1993, when Ron was sentenced to death, there has been a significant shift in sentencing law. First, now we have life without parole. Life without parole was completely not an option on the table in 1993, nor when the Ohio Supreme Court performed the proportionality review in 1995 of his sentence. Second, there has been a shift in the law animated by our evolving standards of decency, which has put in place a new constitutional calculus under which the offense of a young offender has to be viewed. Chief Justice O'Connor described this in concurrence in state law just last year, very eloquently stating that the legal lens through which we view juvenile sentencing has changed. The United States Supreme Court has made clear that courts must treat youth who commit murders and other serious crimes differently from adults who commit those same crimes. In the capital context, the Eighth Amendment applies with special force because of the seriousness of the sentence to be imposed. The Ohio Supreme Court's proportionality review in this case occurred in 1995 and balanced the aggravating factor in this case against the mitigating evidence which was presented by Mr. Phillips at trial. However, youth was improperly weighted and not afforded the proper weight that youth must be given under the current calculus in place at the time now when his sentence is to be inflicted upon him in just a little over 120 days on January 21st. The Ohio Supreme Court stated that when a defendant kills at the age of 18 or 19, the element of youth pursuant to the revised code 292904B4, which is youth, is entitled to little weight. So accordingly, they assigned it little weight. But we know in December of last year in State v. Pickens that when a 19-year-old offender commits a crime, that the Supreme Court now assigns significant weight to youth pursuant to 292904B4. Similarly, the other mitigating evidence that that Ron was able to present at trial, which wasn't much, was impermissibly diminished because of his youth, and the mitigating value wasn't properly weighed. Evidence of lack of his prior criminal history or prior latency adjudication was dismissed when and the court stated that his record of rebelling against authority and his suspensions from school weighed against this factor. Also, when members of Ron's family and his neighbor described him as a hardworking individual who generally respected authority and extended help to others, this was similarly diminished by his pointing to his school record and the number of suspensions on various occasions for fighting and threatening another student. Even though his mental and emotional problems were somewhat presented, he was described as a rather simple, emotionally immature, psychologically inadequate person. The court noted that immaturity deserved little, if any, mitigating weight because many, if not most, murderers are immature. However, Mr. Phillips was more like a 12-year-old at the time. That was the testimony. That the mitigating value of his youth was discounted because his whole school record supported that he was a violent person. However, it was noted that this was out of character for him, completely uncharacteristic. And the testimony about him was that he was very young, very childlike. His neighbor testified that he was 18 going on 12. The defense psychologist noted that his assessment of it was that he was more like a person between the ages of 11 and 12 in that early stage of development because his focus was fixated on himself and other elements, particularly noting his obsession with building toy car models, and his father also discussed this, that Ron had over 300 toy cars that he had assembled decorating his room, and that when someone would come over to the house to visit the Phillips family, that he would run and show them this little, 1950s Cadillac that looked just like Elvis Presley's car, and that his father said that, even though he wanted to be an adult, he was still a child. This is a 19-year-old who comes downstairs and shows someone a car, and that this was his whole life up until the time that he met Faye Evans. And that was his first serious relationship, and she was a woman 7 years his senior. The testimony is that he was not well equipped to handle this situation. Unfortunately, none of these factors were given the proper weight in this assessment, and none of the additional mitigating evidence which has come forth since has ever been evaluated by a state court. Some of the evidence was presented in federal court. That's true, but unfortunately, because of the piecemeal nature of litigation, capital litigation, the whole wealth of the information has never been evaluated by court. Specifically, matters have come out about his sexual abuse, and because of the underlying nature of the crime, sexual abuse that was endured by Mr. Phillips and that he witnessed as a child in his household is relevant to the acts in this case. Because of the evolution of the case law, we now know that young offenders are to be treated differently because they have diminished culpability in comparison to their fully formed adult counterparts. We have specific information about Mr. Phillips here, and we have information about youth in this age category in particular, that when Roper assigned the age of 18 as the cutoff, and noted that it was an arbitrary cutoff or a necessary cutoff, was because that 18 is a line that society draws the line for many choices, the line between adulthood and childhood for many factors. But for decisions that involve judgment, that involve the ability for one to be able to control their impulses, make reasoned decisions, all the faculties that are involved here, at issue here, that are the immutable characteristics of youth. They impose upon a person in this category who is not fully formed a disability that is defined and distinct.
How do we determine that the trial court didn't give the proper weight to the mitigating evidence?
The trial court's opinion is very sparse, Your Honor, as far as their weighing. What we really have to go on is the decision from the Ohio Supreme Court, which goes through in more detail the specific factors. We're pointing to outdated case law, specifically State v. Slagle. Says that 18 and 19-year-olds, that those offenders that had been held, that is appropriate to impose that sentence, and that the youth itself deserves little weight. So there was not a significant amount of consideration given there. Youth as a concept, as an issue, youth was a chronological number, and it was assigned a specific amount of weight. What we're saying here now is that how we understand now youth is a concept is radically changed. In Roper, the way the court has described it and has continuously reaffirmed it is that youth is a condition, and it is a period in life when a person is most susceptible to peer pressure from all the vulnerabilities, all of the things that make a person more likely to commit crime, but all the things that also make them less culpable for those actions, because we can't really tell if you can assign the actions of a person in that at such a young age, if that is truly a mark of incorrigibility, if they're truly beyond repair, if they truly deserve to die. We can't assign that mark upon them without the accuracy that is necessary in a capital case.
I presume there is a sentencing memorandum in the record.
Correct.
So we can flesh out the court's reasoning from that document.
Yes, Your Honor.
Thank you.
What we know now is significantly different from what we know in 1993. Mr. Phillips was prevented from knowing the facts that about his own mental status, about what it means to be young, and was unable to know the way society would evolve and the way that we would have to look at these factors today. The sentence was imposed upon him in 1993 with a framework and a reasoning that does not apply today in 2015 and 2016 when his sentence will be inflicted upon him. The Eighth Amendment specifically speaks to the infliction of the sentence. It's our position that if the sentence is inflicted upon Mr. Phillips, that will be unconstitutional in his particular case because he's never had the merit-based assessment to look at him and all the factors in his case, the underlying crime, his particular culpability, and whether or not he deserves to die as well.
You, pardon me for interrupting, but you made reference in your brief to things that he did not know at the time that he was sentenced. And if I understand it correctly, one of those things was that he was suffered abuse as a minor, sexual abuse. But did he not know that?
He knew it himself, Your Honor, but he was not able to share it at that time. He was not able to come forth as a victim of abuse himself, and also because of his relationship with counsel, his inability to trust others, which were all...
So he didn't disclose it before the sentencing?
No, he did not disclose it until he was very close to execution, until he was confronted with his death and had to face the facts about his life. So that is when he came forward with that information. It was suspected and first entered the record in federal court that Dr. Smith, Robert Smith's assessment of the record and of what abuse was endured by his siblings, that it was highly unlikely that he would escape such similar abuse, and given his individual characteristics and his manifestations, his psychological profile, that he was likely a sufferer of abuse as well. So it is consistent. His coming forward with it merely confirmed a fact that was believed to be true.
Thank you.
And I will reserve the remainder of my time for rebuttal. Thank you.
May it please the court, Richard Casay representing the state of Ohio in this case. This case is a good example of why we have 2953-23 as part of the law in this state. What is apparently is being asked for here is for this court to engage in a de novo independent review of alleged mitigating factors versus the aggravating circumstance. Now, that was done 20 years ago. The new evidence, and the statute only speaks to new evidence, that is, evidence either new case law, we don't have that, or evidence that the defendant was unavoidably prevented from discovering. Now, what is the new evidence that we're talking about here? Youth. Youth is not evidence. Youth is a status. If the law, when Mr. Phillips committed his offenses, was such that he could not be sentenced to death, there would never have been a mitigation hearing. There would have been a guilt phase and a sentence. So to now say that he was 19 when he committed these crimes, and 20 years later, he wants this court to say that he can't be executed, well, that is not covered by 2953-23, because youth is not evidence. What he is trying to do is get a declaratory judgment that the Ohio statutes concerning age relative to capital punishment are unconstitutional. That's what he's saying. That's not part of an untimely and successive petition for post-conviction relief. If he feels that strongly about it, courts are still open. He can file his declaratory judgment, and the Ohio Attorney General has to take part. The Ohio Attorney General isn't here before this court, and that officer has got to be part of any case, particularly a declaratory judgment, where a state statute is alleged to be unconstitutional. That's putting aside the fact that there's no case that he cites where a court says that if you're 19, you're too young. There's no case from the U.S. Supreme Court. There's no case in Ohio. There's no case from anywhere. So what exactly are we talking about? As far as youth is concerned, we're not talking about anything. Sexual abuse. 20 years later, 18 years later, Ronald Phillips reveals that I was sexually abused. Some quotes. He was prevented from knowing the facts. Well, who prevented him from knowing the facts?
Well, was there any evidence that emotionally his state was that he had no recollection or any recall of the event?
I can only go from what the Supreme Court of Ohio said when they discussed the mitigating factors. 87 IQ, low average, not mentally impaired, no mental disease. He is emotionally immature, psychologically inadequate. He is such that when his anger builds, it explodes. It seems way out of proportion to what may trigger it. Immaturity deserves little, if any, weight. Many, if most, murderers are immature, and their crimes result from immature selfishness, ego, or rage. Prevented from knowing the facts. Made-up argument. Was not able to share. Made-up argument. Suspected in federal court. Well, if the federal court had these suspicions, the federal court, the Sixth Circuit, devoted around 15 pages to independently weighing the mitigation evidence against the aggravation. This has all been done before, Your Honors. We're not here de novo. We're here 20 years after the fact, after this court had affirmed the denial of the petition for post-conviction relief, and the federal court exhaustively went through this and denied any relief in habeas corpus. The only thing that's really new in this case is that in federal court, Mr. Phillips did not have a Brady claim. And that's in the record, it's in the briefs. Now he does. He thinks he does. So what's going to happen is he's going to go back into federal court with his Brady claim after it is exhausted in the state courts. What's the result? Years and years and more years of delay. That's fine. That's what the law allows him to do. But that's going to be the benefit that Ronald Phillips gets out of all of this. I want to say a little bit about this Brady claim. This trial occurred in August of 1993. Mr. Cox was the county coroner at that time. He developed the desire or the wish to use the county facilities where he performed his duties as a coroner. He wanted to do work for other counties other than Summit County. In July of '93, thereabouts, county officials became aware of his wish. And it's all in the briefs. Discussion among county officials that he would have to, Mr. Cox would have to obey legal and ethical guidelines. Shortly after that, and again, this is before the testimony of trial, there was a meeting with Bill Hartung, who at the time was a high-ranking county official, not the executive, but more or less the second in command, and Fred Zook from the prosecutor's office. Fred at that time was the head of the criminal division. Mr. Cox was there. And they talked about this. And he was advised, Cox was advised, again, this is in the record, you can do it if you follow the statute. The statute at that time, and for all I know, it will still provide that this is a legal activity as long as you basically have a cost remuneration component. In other words, you're going to
From
use...
the other parties, not so that it was not falling on the city or the county.
Correct. If you're going to use county facilities, county wants to be reimbursed. Nothing wrong with that. So Mr. Cox is told, you can do it, just follow the law. The statute allows you to do it, just follow the statute. Now, 20 years later, this is a Brady violation. Can I do something? Yeah, I can do it. You can do it, just be legal. Now this has, again, 20 years later, morphed into a Brady violation, which requires that had the jury known that Mr. Cox was told, you can do what you want to do as long as you follow the law, they would have disbelieved him. It's absurd to even come forward with this claim. In my opinion, it is absurd. But this is what they will be going to federal court with. That's another story. Later, now then what Mr. Cox does...
Well, let me back up on that to just indicate that the timing of the meetings, which presumably was not public,
no, they would not have been public, in my opinion.
happened to fall right up against Dr. Cox's testimony
Yes.
at trial. So
Yes.
that, it's not like this is completely spurious.
Spurious?
Well, if you were the defendant,
Mm-hmm.
and that would be something that you would want to know.
Well, defendants, sure, they would want to know as much as they can, Your Honor. I'm not quarreling with that.
Well, particularly in light of the fact that it was Dr. Cox's testimony that established
Right.
penal rate as opposed to digital rate, which
Correct.
is important to this case.
Yes. My point is, that is not impeaching evidence under Brady, and it is not material under Brady. It cannot be. It cannot be that you can cross-examine or impeach Dr. Cox. He wasn't given a favor. He wasn't given the county facilities, and they want to say he testified because he's allowed to do what the law allows him to do. That doesn't follow. And prejudice, materiality, no, it isn't there. Now let's speculate. Let's say this comes up today. People asking questions. Say, we had this meeting and this person was told you can do this if they follow the law, and he's going to testify for us. Should we give that to defense counsel? I would say you are under no duty to do so, because it's not true impeachment and it's not material. But in the interest of full disclosure, sure, give it to them. And if they want to do something with it...
Decide.
Pardon me?
Let the court decide.
Well, you could have the court, let the court decide. And the court would probably give them whatever they want, because that's the field we're playing on now. But the law is, it has to be impeaching and it has to be material before the state has an obligation to disclose it. And the prosecutor's opinion came out after this trial was over. And again, he's told, follow the law, you can do it. In the event he doesn't, he sets up shop, independent shop. Prosecutor finds out about it in 1995, is prosecuted and convicted. But to say now, at this point in time, that under 2953-23, because that statute makes no exception for Brady, alleged Brady material, to show by clear and convincing evidence that had the advice given to Mr. Cox, what you want to do is legal, so just follow the law and do it, would have led the jury to disbelieve him, is not a leap, in my opinion, this court can make.
Well, would you take issue with the proposition that he might have had a financial interest in helping to make the state's case?
Well, a financial interest, well, he sued his partners in a public complaint, which back in 1995 was public knowledge. And in the federal habeas case, defense counsel said, yeah, that was out there and they should have known it. So that aspect of the financial interest is not new. It was available to defense counsel. It was in the paper. So are they reading the paper? Do they have a duty to read the paper? Well, it's presumed that if there's something in there that might impact their trial strategy, that they know that. The state doesn't have to say, hey, here, read the newspaper. They had that information. That was his he did have a financial motive. I'm not questioning the foundation of your question, Your Honor, but that was his financial motive, and it was out there. It's public knowledge.
You have about 30 seconds.
Insufficient evidence because Dr. Cox's conclusions were unknowable and wrong. He said the child was penetrated with a penis. Their own experts said Dr. Cox might have been right. Could be right, could be wrong. 20 years later, now this is insufficient evidence. No, it is not. For one thing, their evidence doesn't prove a thing. It supports the testimony. And for another, they are getting into credibility, which is not part of sufficiency. Thank you.
Thank you. You have 3 minutes.
Thank you, Your Honor. Specifically to the issue of Dr. Cox, what's important here is that his perception was in 1993, at this critical time when he was providing the decisive evidence against Ron, was that he needed the approval of the prosecutor's office to go forward to obtain this income to supplement the substantial loss in income which he had faced as a result of his dismissal from the hospital. And was contemporaneously suing not his partners, but it was his employers who dismissed him from the hospital, from that job. I'm sure we all know it's a lot easier now to obtain copies of litigation and things like that filed in the courthouse. In 1995, it was not as easy as it is today, not as accessible. However, we do have a claim in the petition that to the degree that defense counsel should have known this, they were effective in that, they were ineffective in that sense. As far as what information was not shared about Dr. Cox, to that degree, the state induced defense counsel's ineffectiveness. Had they known this information, whether or not they would have chosen to cross-examine specifically about it, they were entitled to know so that they would have the ability to question his motives, to look deeper into this issue, perhaps to obtain their own pathologist, which was done here, and would have arrived at the conclusion that we have here from an objective expert, that to a 95% of medical certainty, that the conclusions that he gave his trial was wrong. In subsequent years, we see that Dr. Cox has a history, also in the petition, that evidence is there for you to review, that with this particular injury in children around the same age, that he has a pattern of making a mistake with this type of injury. This is not the quality of evidence that we have in a capital case to sentence a man to death. We have a lot of open questions, and we're simply asking Your Honors to please remand this back to the trial court so that we can answer these questions. There are a lot of questions put forward, and we these are sufficient operative facts, and that's all the statute requires, that we have sufficient operative facts to merit a hearing to answer these questions. We've been diligently preparing in the interim because we do note that the execution date is scheduled, and we've been preparing, and we can complete that hearing within the time frame because we understand that that date is near. Also, as far as the question of prejudice and whether or not under the second component of the statute, clear and convincing evidence is required. As far as the Brady claim, as we've argued in the petition and the briefing here, is that that burden is unconstitutionally high. That is not the requirement required under Brady for the showing. The Sixth Circuit and federal courts have also opined on this particular issue, and those cases are cited in the briefing, and we would direct your honors to consider those facts. As far as prejudice, we also direct your attention to exhibit number 25. All that was required to save Ron's life was one juror. And there was one juror at that time, even with all of the little evidence that was put on, there was still one person, as evidenced by the juror tally sheet, there was still one person who was willing to say that he was potentially a salvageable human being. We believe that to be true, and we would just like the opportunity to put on evidence to prove that he was denied the ability to have zealous advocacy that he deserves, and that an appropriate weighing and consideration of all the mitigating evidence in the case would show that he is a salvageable human being. Thank you, Your Honor.
Thank you. We will take the case under advisement and send you a copy of our opinion when it is issued.